From the Library of Congress in Washington, D.C.
So good afternoon, everybody. Thank you for attending the fourth session of this afternoon's roundtable. This one is on foreign implementation and interpretation of the WIPO treaties. We have 8 distinguished panelists, and as in prior sessions, we'll just go around the dais, and if you can introduce yourself by name and affiliation, and we'll get started after that.
My name is Sofia Castillo, and I'm a legal fellow at the Copyright Alliance.
Joe DiMona, Vice President, Legal Affairs with BMI in New York.
Christian Genetski, General Counsel, Entertainment Software Association.
Matt Shears, Computer and Communications Industry Association.
Glynn Lunney, Tulane.
Jay Rosenthal, Senior Vice President and General Counsel at the National Music Publishers Association.
Jane Ginsburg, Columbia Law School.
Steve Tepp on behalf of the Global Intellectual Property Center of the U.S. Chamber of Commerce.
Thank you all very much. As in prior sessions, we're going to start with a general question or two and then dive down into some specifics. So I'd like to start off with the question of basically how do foreign laws implement the making available right? And I'm going to be very specific here. I'm talking about WCT Article 8 and WPPT Articles 10 and 14. And how has such implementation provided, in your view, either more or less clarity in these countries in the context of digital distribution? So we're looking for experience abroad on these implementation of these particular articles. And if you can just tip your card and we'll call on Professor Lunney.
So just to start, to me, the process of sort of amending the U.S. copyright law in order to comply with this international treaty strikes me as just a bit disingenuous. I don't see any of my friends from the European Union here. Haven't heard of any trade arbitration seeking to change our law in this respect. So I'm not really sure it's the international treaty that's driving this particular examination of the making available right. That being said, I think that the European Union and the other countries that have adopted the making available right have gone through the same process with respect to internet uses that we've gone through under our public performance and distribution right. Now, they've used a different linguistic framework. They have come to different answers in particular situations. They have come to the same answer in some of the situations. So on the Cablevision case, for example, where the Second Circuit held that to be not copyright infringement. We have the court in Singapore saying it's not copyright infringement, court in Germany initially saying it's not copyright infringement, and then coming back and saying, at least with respect to the first retransmission from the antenna to the subscriber's individual server space, that is a retransmission, and courts in Australia initially saying it's not, and then changing their mind as well. So they've come to some different outcomes in some areas, but on the whole, it's hard to see where their law is in any sense preferable on these issues or clearer on these issues than ours, and we would have to go through the same sort of 10 to 15 year process of litigation to sort out what a making available right would look like in the United States were we to adopt it.
Professor Ginsburg, thank you.
Okay, I guess we might start with the text of the WCT before turning to how it's been implemented. And the language of the WCT treats the making available right as an instance of the right of communication to the public. So without prejudice to a whole bunch of provisions of the Berne Convention where the right of communication to the public is specified, authors of literary and artistic works shall enjoy the exclusive right of authorizing any communication to the public of their works by wireless or wireless means, including the making available to the public of their works in such a way that the members of the public may access these works from a place and at a time individually chosen by them. That language is verbatim in Article 3 of the 2001 European Information Society Directive. And I think that the may access makes clear that this covers not only a completed communication, but the prospect of a communication, the offer of a communication. I think there's a legitimate question whether Article 8 adds something to the Berne Convention. This is relevant to the extent that if the making available right is not implicitly in the Berne Convention, is something new with the WIPO Copyright Treaty, then failing to implement the WIPO Copyright Treaty would not subject us to trade sanctions under the TRIPS, which incorporates Berne, but the WIPO treaties are post-Berne. But if one thinks that Article 8 is a clarification of what the meaning of right of communication to the public is, then the making available right is also subsumed within not only an international obligation, but an enforceable international obligation. So that's a threshold question. Then as to how it's been implemented or understood, Singapore is the only country that has found that a Cablevision Aereo type situation engages no right under copyright. Every other jurisdiction has either under the rubric of making available or other pieces of things, such as the Shift TV case in Germany that Glynn Lunney referred to, have found that there has been a violation of an exclusive right under copyright. As for the European Union, the European Court of Justice in the Svensson case has now made totally clear that the offering of a work, not merely the completed transmission of a work, is a making available to the public. The issue in Svensson ended up turning on whether there was, for there to be a communication to the public, whether there was a new public when the content was initially made available with authorization from website number 1 and subsequent websites linked to that content. But on the front issue of whether or not making that content available via a link was a making available, that is now clear, and that position was also reiterated more recently in the website blocking case that in the Telekabelveen case that the ECJ decided just about a month ago. So I think in terms of international implementation, it is clear that the offer as well as the actual transmission of content is what the making available right is all about. One last comment, because I agree with Glynn on this. We have, in the United States, our approach to put some things in a box called distribution, including digital, and other things in a box called public performance, is something of an outlier. In most other countries, the concept of communication to the public covers digital communications, whether as a stream or as a download.
Thank you very much. Mr. Tepp.
Thank you. So, on the previous, well, 2 panels ago, there was some discussion of room for interpretation and what making available means. I think Professor Ginsburg has just quite articulately pointed out that insofar as the question of making a work available is within the scope of the making available right, it surely must be. That's bolstered further by the text of the Guide to the Copyright and Related Rights Treaties administered by WIPO, which is published by WIPO and which the Copyright Office referenced in its notice of inquiry for this process. To the extent that commenters are offering to you the view that making available does not include making available, it seems to tax credulity, or even more extremely, at least one commenter suggested that if making available does include making available, it's, quote, unprecedented. That seems hard to swallow. To the extent that foreign laws, and getting to the particular question that was posed, implement this right, it seems consistent with the interpretation that making available includes making available. I did a brief survey using the WIPO Lex database of laws in preparation, and trying to look at laws across geographic diversity and diversity of level of development, as well as diversity of whether or not they've actually ratified the WIPO Internet Treaties. Albania, Australia, Brazil, Canada, China, Ecuador, Egypt, the European Union, Ghana, Japan, Nicaragua, and Pakistan, the ones I looked at, and every one of those has implemented a making available right. I can't speak to every jot and tittle of their implementation of that in their national law and their national courts. Of course, there's some room for national law and national interpretation, but the fundamental question of whether or not offering a work, making it available to the public, is within the scope of the making available right and should be implicated under that right in order to comply with the treaties, seems to be fairly clear, both as a matter of the text of the treaty as well as looking at how other countries have implemented it. Thank you.
Thank you. Mr. DiMona.
Oh, okay, thanks. I think there are two areas where the public performance right in the United States falls short of what is happening in Europe. One happens to do with the remote DVR type situation that was addressed by the Cablevision case, and the other has to do with the exemption for downloadings from the public performance right. Taking the first one, we did in our paper, I think we put in evidence from various countries' laws that clearly show that making available right in England and Australia and Japan has been recognized in the communication side to include the mere offering as well as the actual performance. And there was a case called the TV catch-up case in the European Union, which dealt, I believe, with a very similar situation, the Cablevision case, and came out that it was a violation of the making available right. And parenthetically, there have been a few district courts who agreed with that in the United States as well. So I think that that's a problem with the Cablevision decision hinging the existence of the public performing right in the United States on whether or not a copy of a certain kind was made or whether a putatively individual copy was made. I think is just a bad law, bad outcome with server. The cost of memory getting cheaper and cheaper and cheaper. Anybody can architect a system that creates individual copies in order to avoid copyright. And that's exactly what Aereo did. Having received the invitation, they said, okay, this is great. We'll start providing subscription television with individual antennas. So I think we're falling short there. On the download issue, I think that the court, again, Second Circuit decision here is wrong, I think, on the law, also wrong in the technology. The Copyright Act says public performance by any means, process, now known or hereafter invented. And the court came out with, well, it's a transmission, but only if it's an audible transmission, which is a special kind of process. And I think that's inconsistent. In Europe, it's as Professor Ginsburg was saying, it's been recognized to be a public performance, and collective societies there can license both mechanical and performance and have been doing so for quite a few years now. They treat both streams and transmissions to be both rights. And so, I think that we're a little bit out of step there. On the technology, I think also Professor Ginsburg this morning said that, it's not helpful to think of streams and downloads as being radically poles apart. You can architect a download so that you can hear it right while it's going, while it's downloading. You can similarly make copies of streams, and there are a lot of variations in the middle. So I think we fall short here on that issue as well.
Thank you. Mr. Rosenthal.
A second. Yeah, there we go. First of all, I want to address Joe's comments about that there's a real similarity, at least a growing similarity, between the two types of rights we're talking about here, the public performance, the distribution, reproduction, and that in Europe, there certainly is a different licensing format and a different process that they use to license these rights than we do over here. Now, the Copyright Office is addressing these issues in your study on licensing. Should we be bringing some of these rights together? And all of that, and that's fine, and that's for that particular procedure. But essentially, we shouldn't be looking at the fact that we're a little bit different over here and all the debate we had this morning as really being that significant in the overall points made by Stephen, made by Professor Ginsburg, that this does cover the right and we should move forward in trying to deal with it, whether through legislation eventually or not. I'm not sure, looking at Europe and what they've done, because they've done it in many different ways, is that instructive to us. I think it is good that we can look at the results over there and see that they have come to some different results than what some want over here. Just one other point about international law and the issue of the free trade agreements. The free trade agreements did not really concern me that much in terms of us being really in violation of them until the situation has arisen with Antigua. And I think that we do have to, and I think you have to take into context that now we have a situation where a country has brought an action against the United States for a violation of international law under WTO, and now they are engaging in a process where they are effectively giving away U.S. copyrighted works. Not much, and it is Antigua, yes, but the point is that all of a sudden the seriousness of our, let's say, looking at the free trade agreements and adhering to them in a way that would not get us into trouble with the WTO, I think is much more important now because of that, and should be taken into consideration as you guys are reviewing these topics.
Thank you. Mr. Schruers?
So, Professor Lunney started by pointing out that he wasn't aware of any of our European colleagues sort of wringing their hands about the state of U.S. law. And as he said that, I was thinking that at least recently, the shoe's been on the other foot. Many here in the U.S. were wringing hands about whether or not the European Court of Justice's Svensson opinion was going to render a result whereby all hyperlinks on the internet needed to be licensed. And I think that would have been an unfortunate and absurd result, which didn't occur only because of a somewhat convoluted opinion, which Professor Ginsburg alluded to, which seeming to suggest that whether if the new audience is coterminous with the original audience, then anyway. There are logical readings of the opinion. There are also very illogical readings of the opinion, and had there been an illogical result, that would have come out of an implementation of communications to the public. And so, having seen us just narrowly dodge a bullet, I mean, we don't actually know how that's going to play out over time, but assuming we've dodged the bullet, it seems a uniquely inopportune time to sort of revisit that issue here and sort of take on the same risk. And we certainly, it would do no favors for the credibility of copyright law to say that every link needs a license. And I don't think anybody wants that result to occur in U.S. copyright law. So that is, I hope, a less probable outcome here. But again, in the sort of European example, in our preparations for the European consultation that recently occurred, one of the things that I heard extensively was concerns about multiple demands for one exploitation of the work. I mean, we have that now in Europe. We have that to some degree here in the United States, and any interpretation that appears to expand distribution so that one exploitation of the work means that perhaps not only the reproduction and public performance rights are triggered, but also as some making available right for a use of the work, as we're seeing in Europe. That seems to me to be a very real risk, and it would be unfortunate if some report or statement from the Copyright Office were to be the impetus for a lot of rights holders to say, well, now these works have already been given to the public in some licensed manner, but perhaps my newfound making available rights means that I'm entitled to take a cut for actions that people thought were adequately licensed. I think that's a very real outcome, and one that I'm concerned about.
Thank you. Next, Mr. Genetski, then Professor Ginsburg, and then I'm going to have a follow-up question about the structure of various copyright laws.
Thank you. So building on the point that Matthew closed there with, and going back to a specific example that Joe and Jay both raised as well, and coming at it from a slightly different perspective, which is, the big question in front of us is whether there's some action the Copyright Office should take to recommend or as an impetus towards legislative action on a making available right here to be consistent with the WIPO treaties. And the perspective that I bring on behalf of the video game industry is just the practical business implication that might result from including a making available notion or right, whether it's layered on as another right under 106 or it's incorporated into existing rights. I think that looking at the foreign implementations, the different approaches that have been taken by different countries around the world is instructive for us in thinking about what the consequences of any action here, other than sort of holding to what has seemed to be the overwhelming consensus point all day, that we're in an okay spot now for the most part with the umbrella approach we've taken. I'd look at Canada, and looking specifically at the issue that Joe raised about under U.S. law, the distinction between a download and a stream, and a download being covered under distribution right, stream being covered under the public performance right, and the EU taking a much different approach, which has real implications for collection societies and licensing regimes. Canada has, under a case that my trade association was the named plaintiff in, ESA versus SOCAN, took the same approach as U.S. law. It's communication right, not public performance in Canada, but again, split stream and download. Had strong language about not stacking royalties, not layering rights, collecting twice for the same act, as Matthew mentioned. And in the wake of that decision, in an overlap of just a few months, Canada passed its amendments to its Copyright Act, including incorporating a making available provision, whether it's a separate right or not is the subject of a lot of debate now, but into its communication right. And solely within its communication right, what that has spawned is, within a year of a case that was litigated from the Copyright Board through every intermediate court in Canada and ultimately decided by the Canadian Supreme Court, we're back to square one in the Copyright Board again, starting over, having arguments from very smart people on both sides about what the implication of that making available language being put into the communication right is. And I don't want to relitigate the issue here today, but the point is we're going to go down that same road again to reach a resolution, and you've got very different interpretations about whether that upset the apple cart. There are a lot of existing licensing practices that the companies that I represent have built into their ability to incorporate music into their works. They thought they had clarity. Some well-intentioned action has now meant we've got several more years of confusion on that issue.
Admit it, you enjoyed the first SOCAN case so much that you really are looking forward to doing it a second time.
Thank you very much. I'd like to follow up on one or two issues you raised, but first, Professor Ginsburg.
Yeah, well, it'll be interesting to see what the Copyright Board of Canada does, which I think it should be doing shortly at this point, in determining whether the enactment of a making available right in Canada, whether that in effect replaces the ESA SOCAN case or incorporates the ESA SOCAN case. Of course, much of the debate in that case is also about whether a making available right includes prospective, or the offering to download of a download. So that will be another country's implementation to watch. I just wanted to say something more about Svensson. In Svensson, the new public concept, which is not free of controversy, came to the rescue, because otherwise it would have been extremely problematic. And I think it was, for Europe, a more elegant solution than implied license, which I think is perhaps the way we would go. But it should also be recognized that in taking that route, the European Court of Justice ruled that it's a making available, but there's no new public if the initial communication from website number one was authorized. But if that initial communication from website number one wasn't authorized, then it's a making available. It is a communication to the public, and it's a direct violation. It's not a theory of secondary liability. In the first panel, we talked a little bit about whether these sorts of situations should be adjudicated as a matter of secondary liability. I think in the EU, one upshot of Swenson is that if that initial communication is not an authorized communication, you have a direct violation, and it's not based on secondary liability.
Thank you very much. I actually was hoping to turn to another question, but I see that there's 2 flags up. So, Mr. Schruers.
I'll be really quick. I just sort of, I think I agree with everything Professor Ginsburg said about the interpretation of Svensson, and I was sort of thinking about how that would play. Right now we're sort of seeing a similar fact pattern, and I'm a few days behind on the news, but I have seen that Quentin Tarantino has been litigating about a script that was made available that was leaked. You know, it's sort of applying the sort of Svensson fact pattern where you've got, you know, the initial communication was not authorized, and then somebody linking to something that's newsworthy. You know, I sort of see a situation where you have people linking to something of public note, and that may well, under making available, be a direct violation where we wouldn't want it to be. And I just, you know, I find it very troubling to think that we, at a time when we, as I said, just dodged a bullet, I think, in Europe, would want to sort of revisit and reintroduce that same uncertainty here, is, you know, troubling.
Thank you, Professor Lunney.
I'll try to be equally brief. And so my point would be that instead of looking at what they have and what we have and saying, oh, they have this, that would be nice, let's take it on, we need to look at the real-world consequences of adopting their approach. It may be more elegant, as Professor Ginsburg has said, but do we really want strict liability if you link to a site that's originally unauthorized? That puts the burden on the linker to know whether that original site is authorized or unauthorized, as opposed to our current secondary liability approach, which puts the burden on the copyright owner to provide notice and then follow with the takedown. That procedure is not perfect, but neither procedure is perfect, and we need to compare their relative costs and benefits. Just saying they have one and we have the other doesn't advance the ball very far.
I think Professor Ginsburg wants the last word.
512D, which we have and they don't. The equivalent of 512D is a matter of interpretation. So far in some national courts have come up with a 512D equivalent, but it's not yet Europeanized. So, and I should have mentioned in that landscape that we also have 512D as a part of the consideration of whether linking, deep linking, or framing a website would be a making available, or whatever we are calling the patchwork of rights that we claim end up being the equivalent of making available.
Thank you. There's 2 big trains of thought that I'd like to come back to, and so just to place a marker, one, I'd like to go back to a question that kind of takes up on what Mr. Genetski was saying about real-world consequences with respect to statutory design and how the laws look, and then I'd like to come back to this question about linking, and more importantly, the question of, you know, not all countries have secondary liability principles, and then how does that work in their implementation of making available rights. So putting a pause on the second, to go back to the first question I have, and I'll take Professor Lunney's admonition that we're not all international lawyers, so we're going to focus the question here just on their statutory language, not necessarily case law. There are countries around the world that have very explicit ways in which they break out the communication to the public, right, especially in the area of works. So I have seen laws that will start with an overarching chapeau of here's this, you know, communication to the public, and then they will list about anywhere between 10 to 15 rights. Sometimes it will include the express making available right if it's been more recently amended. In other cases, it won't. So this is not a new structure of listing very descriptive rights. So you'll have broadcasting, rebroadcasting, public performance, loudspeaker. You'll have a very long list. So my question to the panel is, what's your experience in terms of real-world licensing issues in these foreign countries and real-world, perhaps, enforcement issues with respect to those countries that have these very detailed communications to the public structures in their law that obviously have a making available component. I was wondering if you have any views on that. Professor Lunney.
Well, it's a question of all what you're used to, right? So if that's what you've grown up with, then it seems right and just and the only sensible way of doing it in the world, and you adjust your contract language appropriately. I think the concern that my two commenters on the right raised is if you already have the contracts or licenses in place, and then you come along and change the right structure, how does that, do you grandfather in those pre-existing license arrangements?
Well, to follow up, I think that's my exact question, because some countries do and have had these very detailed right structures, and then the way in which they amended their law as they perhaps implemented their treaty obligations when they joined the WCT is to add basically the last including phrase from our WCT Article 8. And so that would upset potentially new and old contracts. I was just wondering if anyone on the panel had any additional specific interest or information on perhaps cases which they were involved that had happened.
So I will apologize that I can't answer the question. There are international scholars here far more studied on the subject than I am, but I will make the I hope obvious point that sort of the more circles there are in the Venn diagram, the more concerns there are about things falling between the circles, one, and then the sort of problem that Christian's example with SOCAN illustrates so well is that multiple circles overlapping, and to do one exercise, you've got to check multiple boxes, and then as soon as you add another one to the equation, right, you get that many more times the number of potential conflicts, right? It's sort of the n times n minus 1, and so the larger n is, the more complex we have. We already have 6 enumerated rights, and this will cause that much more complexity should we undertake the issue, the change.
Thank you, Ms. Castillo.
Yes, I also don't have international law expertise, so I can't answer the exact question that you're asking, but I think in terms of things that could be helpful for the Copyright Office to take into account in terms of issuing some kind of guidance to courts is, and referring back to the Charming Betsy doctrine that was mentioned several times this morning, where courts where possible should interpret statutes in accordance with the text and the spirit of international treaties. There are two things in the WCT that could be helpful. One is one that Professor Ginsburg has already referred to, and it's the use of the permissive language where they say by wire or wireless means, including the making available to the public of their works in such a way that members of the public may access these works from a place and at a time individually chosen by them. So basically, I think telling the courts that the use of that permissive language indicates that the offer of a work triggers the right, and that there is no international requirement for proof of actual access to the work, that might be helpful. The other thing that might be helpful is looking in terms of determining the spirit of the treaty, is looking at the preamble, and the first the first paragraph explains that the treaty seeks to develop and maintain protection in a manner as effective and uniform as possible to copyright owners. And so I think those two things might be helpful for the Copyright Office to take on any guidance that would be helpful to the courts. Thank you.
Thank you. Mr. Rosenthal.
We haven't been involved directly in any proceedings over there, but if you're asking how things are licensed, the process, almost all the countries have societies that engage in the licensing of making available, and some of them break it down between their two different societies. One, like in France, SACEM, and then SDRM does the mechanicals, SACEM doing the representation rights that they speak of over there. In Germany, GEMA does them both. And I believe in the United Kingdom, I think they are done both, but they have also merged recently, and we can find out for you, the exact nature, if that's what you're asking. We could also supplement your record here by getting some information from the international societies who represent music publishers, ICMP, maybe CISIC, about this particular issue of how are they licensed through the societies, if that would help.
Thank you. Mr. Genetski.
I'll start by echoing the I'm not an international law scholar disclaimer, but I think I can address your question at a high level from the perspective of the industry I represent, because we look at this issue in broad in kind of from two different perspectives. So our members are certainly they create a lot of intellectual property. Strong copyright regimes are very important to us instinctively and practically. And when we go around the world to enforce those rights, I mean, what you typically the analysis you will conduct, you won't start with the specific lists and the rights and how they're protected. You'll start with what's the problem that we're dealing with. How is the value of our intellectual property being compromised by a certain service or individual or group of individuals? Instinctively, most of the member companies, we're U.S. Trade Association, our member companies will approach that through their own lens and think of our own Copyright Act first and sort of intuitively understand what would be infringing about the conduct here. And then you go to that list, and you go through the rights, and then you go through, the precedents in that country and the way those rights have been interpreted, and you try to match, the activity to what makes it unlawful in a specific jurisdiction. We really follow the same approach when we're sitting in the opposite side, which is we want to incorporate other copyrighted works into the audiovisual works, into a downloadable game. We want to have music. There what we'll do is figure out what rights do we need to clear and how do we clear them under a certain jurisdiction. And so it's the same practical approach, which goes back again to the larger point of any change for the sake of clarification, well-intentioned change where there's already fairly well-established practices under current things can be upsetting.
Thank you. Let me turn to back to a little bit of what we were talking about with Fenton. And the whole issue of how secondary liability might relate to the effective enforcement or of the availability of the making available right itself. So, as I mentioned earlier, not all countries have a secondary liability concept. I know it sounds shocking, but they don't. And I guess a couple of questions. Are you aware of any cases or practices in those countries that do not have a secondary liability case, a concept, and there's been making available litigation, or perhaps the converse? I'm trying to figure out, and I would be interested in getting more information from the experts on that. I think we've had a little bit of an example of Svensson, but I was wondering if there's any other examples you might be able to provide. Professor Ginsburg.
I don't have the citation, but I believe Spain does not have the concept of secondary liability for copyright infringement, and Spain has a very, very high level of, let us call it, unauthorized activity. They may even be on our watch list, but they are a kind of a notorious example of an EU country that does not recognize the doctrine.
So I guess I'll take advantage of your knowledge there. How do you think in a future case Spain might respect the recent Svensson case?
Well, since it's not a theory of secondary liability, that's not a problem. The problem is what happens if you're providing instrumentalities, but it doesn't come within the ambit of the making available right. So if you're providing instrumentalities for copying, but outside of a making available context, that seems to be a big hole.
Yeah, I think, and there's probably some more experience here on the experience in Spain, but Spain does have as you mentioned, a challenge problem with piracy in the online environment, especially involving linking sites. And so I'm curious to know how. I'm going to take that back. I guess let me go back to perhaps another region. There's other countries in Latin America that also don't have a concept of secondary liability in the copyright context. I think there's been some struggle in some nations to try to extend just regular tort to that, but they've been unsuccessful. I was wondering if maybe in Latin America or in Asia, whether anyone has any other ideas or information to provide to the record on how those countries are implementing make available. Mr. Tepp.
I think by and large, making available gets implemented as a matter of direct liability. That seems more likely the circumstance under which it'll come up. Obviously, there are some countries that don't have secondary liability at all. There are many countries that have secondary liability in forms that are significantly different than in the United States, through tort law, through aiding and abetting type statutes on the criminal side. But of course, where I think what I would urge you to keep in mind is that what you're being urged by some commenters is that making a work available should not and does not, some are arguing, implicate any exclusive right under U.S. law. Well, if there's no direct infringer, the secondary liability analysis is extremely brief. There is none. So I think the focus I would urge you to maintain is on the direct liability question and whether or not the United States is providing a making available right in a way that complies with any plain meaning of that term if making a work available does not implicate any exclusive right under U.S. law. I don't see how it could.
Thank you. Maybe if we can go back to some higher level questions on linking. Are you aware of any other countries' laws or practices that make the distinction between linking to legitimate materials and linking to infringing materials? I mean, we've had some discussion of Svensson, but I know this probably will raise, again, the question that, or the observation that Mr. Tepp just made on what could possibly be direct liability, what would be secondary liability. So in the area of linking to different kinds of materials, do you have any comments or observations? I'm stumping. What'd you say?
I was going to actually say, I don't have any further questions, but that it's just 4:08, so we actually only have a few more minutes left in this panel anyway. Normally we would say we would want to use those last couple of minutes for audience participation, but we have an audience participation session next, so we probably don't need to do that. So maybe just one or two final questions, and then we'll turn it over to the audience participation.
I guess I'll toss out sort of another higher level question. Since the implementation of the treaties in 2002, we've reached the magic number of 90, if that's a magic number, but that's quite a large number of member states for a relatively young treaty. Do you have any observations or general trends, either at the rate of implementation or the regions of implementation or the issues related to implementation, given the recent decade of success, I would say, and the widespread adherence to the treaties?
I think Mr. Rosenthal looks like he wants to answer that question.
I really don't. Actually, no. On all of these points, these are very, obviously important questions, and I think that maybe if we were given some, guidance beforehand on some of these questions, we might have been able to come to you with answers. If this is important to your deliberations, we will work on getting you some of the answers to this, and we can supplement again. Your record on these points. I mean, as you raise these questions, I'm like, boy, this is something I'd like to know more about. So we're open to working with you on that and getting you this from the organizations in Europe and in Latin America that can give you some good answers on it.
Thank you. We appreciate that, Mr. Tepp.
It's a very broad question, essentially asking about implementation both in national law and in national courts in 90 different countries. I'm not prepared to speak categorically in absolute terms as to 90 countries. I can tell you that the work I've done indicates that overwhelmingly the implementation is consistent with the view that offering a work, making it available, is and does implicate an exclusive right under national law in compliance with the WIPO Internet Treaties. As I mentioned earlier, I also found some countries that have not yet officially ratified those treaties, but appear to have at least implemented the making available right, consistent, again, with that interpretation of the treaties. And I agree with the observation that to have, in such a short time, so many countries adopt the treaties speaks to their importance. And just sort of 2 points that I'll make in the vein of closing remarks. One is there was a question raised earlier about whether any of our trading partners or other governments really care much about what U.S. law is on this point. I can speak from personal experience that the government of Japan has inquired about our compliance with the making available right in particular for years, and that it was important to them, and they're not entirely convinced that we're complying with it, and I understand why, although I, of course, when I was a representative of the U.S. government, always maintained that we were pristine. My final point is that in this overall atmosphere of global challenges to copyright protection and enforcement, where we have 90 countries that have implemented, ratified the treaties, and the United States having to ask itself whether we actually fully comply with it, it is not a helpful situation for us to be in. The United States is looked to as a global leader in intellectual property generally, and copyright in particular, and I think it's important that we provide the best possible example of implementation of and enforcement of obligations that we ask other countries to undertake to provide that sort of fair compensation to creative authors and industries. Thank you.
Thank you, Professor Ginsburg.
Japan did decide a Cablevision-like case and found that it was a violation of their rights. Two further thoughts. One inspired by Steve Tepp, and which also gets back to the Charming Betsy doctrine, because there seems to be some disagreement about whether the Charming Betsy doctrine actually matters, because we've sometimes had a tendency to go it our own way and not make every effort to interpret our copyright law in light of international obligations, assuming that we agree about what those international obligations are. And we do have a somewhat inglorious record when it comes to the Berne Convention and notably moral rights. I think Steve has a point that it doesn't make us look good to take a truculent attitude towards our international obligations. And also the Supreme Court attributed to Congress when it came to the Uruguay Round Amendments Act and the restoration of copyright in foreign works prematurely in the public domain in the United States, that Congress had an intention of unstinting adherence to Berne. And I suppose that one might try to argue that when the position was taken that we didn't need to amend our Copyright Act because we had, through bits and pieces, we had the equivalent of a making available right, that we should be unstinting about that as well. The last comment, which might open a hornet's nest, is there is a private international law problem with the making available right, which is where does the act which gives rise to liability occur? Does it occur in the country from which the work is made available? Does it occur in the country to which the work is made available? Does it occur in both? The ECJ in the Football Data Co. case determined that where a particular country has been targeted for the communication, the work was certainly made available to that country, but also preserve the possibility that the country from which the work is made available might also be a locus of the making available right. This is an important issue because of the question of enforceability. Because if you have a transnational making available, which you almost certainly do, you wouldn't want to conceive of the right in a way that would allow opportunistic restructuring of the offering of content. So it goes back to something that we referred to earlier this morning with respect to the reproduction right. If the copies are being made on a server offshore, does that elude effective copyright enforcement or enjoyment of rights in the United States? So the from to question is one that I think also needs to be thought about in the context of a making available right or its equivalents in U.S. law.
Thank you. Our final two, well now three, we'll just go down the road this way. So Mr. DiMona, Mr. Schruers, and Professor Lunney.
Thanks, Maria. I just want to conclude my participation by saying that we're in a world that's awash in piracy today, and we have creators who are struggling. I want to echo a word that my colleague John Viter said this morning: songwriters, authors, and creators. They need strong protection, and as far as I'm aware, entertainment products are one of the only positive balance of trade that the United States has nowadays, where we're actually making more money from foreign sources than we're spending. We need to protect our culture in the future. We need to protect creators. And my own personal view is that we need very robust copyright rights in the digital age to help with this problem. And narrow exemptions. I'm in favor of exemptions as much as the next guy if there's a meritorious argument to be made. The copyright law is filled with exemptions where Congress looked at a particular situation and said, if you're paying this right, you don't have to pay that right. But that should be thought of, and the case should be made for those. Final comment I will make, go back to your question, Maria, about how would you fix the law. Should you write a very, very detailed public communication right with a bunch of subparts, or should you just have a broad statement? My sense is the broad statement is better, but you really is a fine line there, because if Congress tries to write down every single possibility of a scenario, they're not going to be able to do it. And technology evolves so quickly that they will just miss a few. Things happen. No one can understand. So that's a risk there. If, on the other hand, you go with the broad statement and say it should cover everything, then you run the risk, like the court did in Cablevision, where they just make one misinterpretation and all of a sudden you've got this loophole that you just can't remedy. So I don't know exactly what to do with that, but I think broadly enunciated principles with particular narrow exemptions is probably my feeling, and I think that the law needs to be made more robust, not less, and that's it. That's all I want to say on that.
Thank you. Just for the record, I was asking for examples outside the U.S. I wasn't saying that the Congress was going to write a very detailed list. Mr. Schruers.
So one of the other areas where the U.S. has a very strong positive balance of trade is the export of digital services. It's one of our fastest growing exports, and certainly we wouldn't want to do anything to endanger that. And indeed, other countries have noticed that the fact that Spain, Germany, in the order of France, Germany, and Spain have all now implemented or are considering implementing ancillary right-like proposals, which they can assign to domestic stakeholders to tax internet services that are exercising the quotation right in the Berne Convention. Shows that there is great interest in finding new sources of revenue from existing services, and we wouldn't want to see a making available right here in the United States do something similar. And here we are at the end of the day, and I sort of figured at some point I would find what I was thinking of as the I Crave TV case. So in WIPO, we've been fighting for years now about the WIPO Broadcast Treaty, which is sort of a perennial issue, right? And the one case that was the problem that we need to fix, right? There was always the I Crave TV case that was held up to say, this is why we need a WIPO broadcast treaty. Now, that is either a good example or a bad example. It doesn't really matter. Here, I haven't even heard that example yet. So I sort of came in today thinking, like, I'm going to hear what the case is that is the problem, and then I can go and read the case. And I'm just not sure where it is that a plaintiff brought a case and then could not recover because there was no making available right. And when John Band pointed out in previous panels that there seem to be in many, if not all of these cases, the reproduction right applying, I expected somebody to say, well, that wasn't the case in this case, and that's why we need it. And I haven't heard that. So I feel like we're largely responding to hypotheticals until I hear what that case is. And if someone wants to, email me the citation, I'd be happy to read it.
Professor Lunney.
Just a final thought. Piracy, depending on how you define it, certainly some people think it's rampant, but when we look around the world at all the different legal regimes that different countries have adopted, no one's found the silver bullet. No one's found the magic language you can stick into your Copyright Act that will shut down file sharing, whether peer-to-peer or otherwise. Europe has it. They still have 1,350 petabytes a month of file sharing traffic on their internet backbone. So it doesn't appear that this is really going to help significantly, and I am concerned that it's going to open the doors to some really ambiguous, if we add a broad making available right, it's going to be very unclear what exactly that means in the U.S.
Oh, thank you very much. I think we were going to close it, but I think Professor Ginsburg will have the last word. I will just note that we haven't actually had any audience members sign up so far to make any final remarks. So audience members, if you do want to make any final remarks, please come to the podium. Otherwise, we will close with Professor Ginsburg and any other participants who have final words.
Okay, I'd like to take the focus off of file sharing and piracy, because I think that one of the very important features of a making available right, or an interpretation of the digital distribution right as covering offers and public performances covering offers, is the affirmative side, which is licensing. That there shouldn't be gaps in the panoply of rights that get licensed. And I think that we may have an issue about overlapping rights, and that needs to be worked out. But I think that given the way copyrighted works are enjoyed by the public, there are increasingly variations on access models. And the WIPO treaty says may access. It's all about access. So I think we should think about this not simply in the enforcement context, but in the positive context of what set of rights do we need in order effectively to grant rights so that people may enjoy copyrighted works without the threat of being labeled infringers.
Thank you very much. I want to thank the panelists for this session. Thank you very much. And as the panelists depart, if anybody, as I said, would like to make comments from the audience, please step up to the podium, and we will start with our audience participation session.
So I just wanted to respond to some of the comments that were made in this last panel. One is that there would be no surer way to sort of mobilize public opposition to the Copyright Act than to have a direct infringement liability for linking. I mean, that would be an absolutely horrible idea and would completely discredit the Copyright Act. I mean, the only thing that I can imagine that would discredit the Copyright Act more, or the copyright system more than direct infringement for linking, would be to try to extend copyright term again beyond life plus 70. So, that would probably be the only thing that would be a worse idea than having direct infringement for linking. The second point is that in terms of looking to foreign law for models, yes, it's always good to look to foreign law for interesting approaches, but we should, again, be somewhat consistent and not only look to foreign examples for expansion of rights, but also for interesting exceptions and limitations. And so I note that the UK now is considering, and I I don't understand their parliamentary system, but I understand that they very soon will now have in their copyright law all kinds of exceptions on contracting out. In other words, that contractual limitations on a variety of exceptions will be null and void. I mean, they already have that in the EU software directive and some other places, but this would be in UK law with respect to libraries and educational institutions for a variety of exceptions. So I think that that's something I would commend, looking at contracting out. Or like in Canada with statutory damages, they have a limit on the total amount of statutory damages per transaction for non-commercial use. So that's, I think it's like a 5,000 Canadian dollars. So that would significantly reduce the statutory damages available in a non-commercial use situation.
Thank you very much. Do we have any other not participants, audience members who would like to provide any final remarks? We definitely want to thank all of the participants today. This has been very, very helpful to us in terms of exploring in further detail some of the issues that were raised in the comments. As I mentioned before, there is a possibility that we might ask for further written comments, and if so, we will issue an NOI that asks some additional questions based on some of the conversation that we received here today. We expect to be able to post the transcript of our proceedings in the next several weeks, as well as a videotape of the proceedings as well. So thank you, and we look forward to working with everyone as we explore this issue in further detail. Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.